Hello! What is the Nagoya Protocol and how has it impacted the sharing of the samples? The Nagoya Protocol on Access to Genetic Resources is an extension of the Convention on Biological Diversity. It is an international agreement which aims at sharing the benefits arising from the utilization of genetic resources in a fair and equitable way. It entered into force in October 2014 and has been signed by 136 countries plus the EU, called parties. The protocol covers the use for research of non-human genetic resources such as plants, animals, pathogens, as well as traditional knowledge associated with these resources. We will address the questions of whether the scope covers digital sequence information, DSI, taxonomy, and the human microbiome later. The scope is research, so the use of material as an ingredient for cosmetics, for example, or foodstuffs is not covered, but analysis with the objective of developing a drug is. In essence, the user agrees that he will share part of the benefits generated by the research with the provider of the material, in return gaining access to the resource. To regulate and document access and benefit sharing, ABS, in each country, parties agree to appoint a national focal point, NFP, and competent national authority, CNA. The NFP provides information to all involved. CNA grant the access or permit and issue written evidence that access requirements have been met. It also advises on procedures and requirements for obtaining prior informed consent, PIC, and entering into mutually agreed terms, MIT. PIC, not to be confused with informed consent by a donor, documents the granting of access to genetic resources before they are used, while MAT documents the terms of that access, in particular what benefits the provider will receive. An ABS clearinghouse is set up by the Convention to track activity about the protocol. It is an essential source of information for users and providers, structured by country, giving for each country the names of the NFP and CNA, the applicable national laws, the list of internationally recognized certificates of compliance, IRCC, and more. An IRCC is a publicly available permit or equivalent confirming that PIC and MAT have been agreed by a CNA for resource. That describes in short form what the Nagoya Protocol is and how it should work. The protocol was signed 10 years ago, in 2014, but progress has been hesitant, not for any lack of underlying justification, but from complexity, inertia, and avoidance. Let us look from a pragmatic point of view at what it means for researchers wishing to share samples. The European Nagoya Protocol regulation imposes the so-called due diligence declaration as a duty on users. Users are required to exercise due care to determine whether their use of biological resources is legal and must make a declaration to the national authority for research projects. Penalties are stiff. The protocol itself is not the agreement to which the researchers must comply. The protocol only binds parties to having local national laws about ABS in place, and it is these that must be followed. So researchers must find the applicable national laws for the two countries and comply with all of them. Many will date from before 2014. Many countries are not party to the protocol: USA, Canada, Australia, Russia, Chile, and Colombia. There is also a wide variation in the diligence with which ABS measures are applied. this naturally leads to avoidance. Users seeking to deal with countries who are not party or with countries whose regime is less constraining. More specifically, there may be unreasonable expectations on the part of the provider about rights or benefits to be gained from the user. These unreasonable expectations may come from the provider institute or from the national law. Users, for example, might be put off by Article 62 of the DRC Law number 14003 of 11 February 2014, which implies that simply providing genetic resources gives shared intellectual property and joint venture rights to the provider. There is confusion over definitions and scope. Now here, for example, is research defined. Taxonomy as a case in point is usually considered to be research, but France has agreed that taxonomy is outside the scope. The microbiome and DSI as well are discussed at length in legal briefings. For an excellent treatise on how the human microbiome may sometimes be in scope and sometimes not, see Note 2. There is a similar brief for DSI in Note 1. See also the above link for the latest on DSI from the Conference of the Parties, essentially that the COP has not taken a position on DSI. The NFP and CNA are renowned for not responding to requests for information and providing permits. Researchers may well have agreed a collaborative research project, but without a permit from the CNA. It may be illegal to start work. Biobanks are in a difficult situation. The basic activities of biobanking, receiving, processing, storing, and distributing, are not research. They are not in scope, so the protocol does not impose the negotiation of ABS terms. However, if the biobank in addition undertakes sequencing of pathogens, not human DNA, it may. But a more important consideration for biobanks is the often lengthy period between collection and use. The user must comply by negotiating PIC and MAT with the provider, but the research team that collected the samples may be disbanded. The biobank, meanwhile, would like to make its collections as attractive as possible and make the samples available with ABS measures already in place. But since at the time of collection the use is unknown, negotiating ABS measures at that moment is not straightforward. Despite human genetic resources being out of scope, all human biosamples for infectious disease research contain pathogens for analysis and so are in scope. Obtaining a permit requires divulging information about the research, which could be a commercial secret. Pharmaceutical companies are understandably reticent to share such information. All of these issues have hindered the sharing of samples, not least because of fear and uncertainty of non-compliance. In France, for example, conducting R&D on genetic resources without having the required documentation is subject to 1 year imprisonment and a fine of up to 150,000 euros. In South Africa, fines can reach $700,000. Nagoya Protocol is pragmatic practice. To overcome the issues, researchers should proceed pragmatically. It is just not worth studying the protocol itself and attempting to understand and apply its provisions to a given situation. The implementation of the principles of the protocol vary too widely. Researchers should focus their efforts on a case-by-case basis on obtaining the permit or equivalent from the CNA, probably through the good offices of the national partner to the resource exchange. It is in the latter's interests to obtain the permit. Often the request to the CNA can be in form of a simple request for confirmation that the transaction is either out of scope or is approved following the MAT negotiated with the provider institution. Another line successfully taken by DSMZ in their negotiations in Costa Rica is to negotiate a class agreement. See the above link. In this case, DSMZ can distribute deposited microorganisms to third parties for non-commercial research, and such researchers will not need to negotiate PIC and MAT with the Costa Rican CNA. The benefit sharing is pre-established and pre-approved in the MTA between DSMZ and Connect Bio of Costa Rica. The approach could be promising for biobanks who have the resources to provide capacity building benefits for their partners. Before entering into the agreement with their partner, it might be possible to obtain the agreement from the CNA that access to samples provided by the provider institute is acceptably matched by the capacity building benefits received, and that the CNA grants a global permit for the biobank to distribute the samples provided by its partner without further need for a CNA permit. After 10 years, the protocol is still at best work in progress and still provides rich subject matter for academic study and interpretation. But users should focus on obtaining permits or confirmation of waiver on a case-by-case basis from the relevant CNA without attempting to comprehend the ever-shifting patchwork nature of the protocol.